thank you so much, Dr. Krishman, for the introduction. And as you all heard, I'm an employee of the U.S. Patent and Trademark Office, but my remarks today will be strictly of my own and should not be attributed to the U.S. Patent and Trademark Office. Today, I'm going to be discussing the implications of AI on patent law specifically. And as an entry point to do this, primarily, we're going to get into what exactly is artificial intelligence or AI, because it's a term that has a lot of ambiguity around it, and it's fraught for misinterpretation if we're not very clear about what it is that we're speaking about. And as policy regulators around the world have grappled with this issue, I'm going to share today three sort of prominent definitions that exist out there in policy realms. The first of which is from the Organization for Economic Cooperation and Development, which many of you likely are familiar with, is a policy group and intergovernmental organization that sort of drives policy issues for market-based economies. I'll talk about the US Congress's definition that was espoused back in 2019 through some legislation, and also turn to the EU's AI Act definition as well. So starting out here first, the OECD definition is really, I would argue, one of the broader definitions that we have today. So you can see here, it's an AI system which is machine-based, capable of influencing the environment by producing an output for a given set of objectives. It uses machine and or human-based data and inputs to perceive real and or virtual environments, extract these perceptions into models through analysis in an automated manner or manually, and use model inference to formulate options for outcomes. So this last sentence here, that AI systems are designed to operate with varying levels of autonomy, is, in my opinion, it's sort of a future-proofing mechanism that the OECD members put in here, because they're thinking about today we may have some level of autonomy that is more reliant on human interaction, but in the future, these types of AI systems could go much more autonomous, if not, akin to human interactions. The second definition here is a different approach. So this is the US Congress's approach back from the National Defense Authorization Act in 2019, which actually was partial to many other AI initiatives that the US was engaged in that legislation, but particularly in order to have any clarity about what they meant when they talked about AI, they had to actually have an attempt at defining it. And so the approach that the United States Congress took was to sort of make 5 different branches of definitions, if you will. So you can see the first one is any artificial system performing tasks under varying and unpredictable circumstances without significant human oversight, or that can learn from experience and improve performance when exposed to data sets. Again, the US here is defining this in terms of a system. In the second iteration here, developing computer software or physical hardware to solve tasks requiring human-like perception. Then a third iteration, an artificial system designed to think or act like a human, including cognitive architectures and neural networks. Fourth, a set of techniques, including machine learning, and that's really important that we've said machine learning expressly here, I think, that is designed to approximate a cognitive task. And the last fifth one is an artificial system designed to act rationally, including an intelligent software agent or embodied robot that achieves. So now we're getting more into sort of what it could be in sort of a robotic sense in this last one. So 5 different definitions, all equally categorized as AI in the US. Now, I think the award for concision may go to the European Union here, because in their AI Act, what they've done again is defined not just AI, but an AI system, meaning software developed with one or more of the techniques and approaches listed in an annex, which you can see my note there, and can, for a given set of human-defined objectives, generate outputs such as content, predictions, recommendations, or decisions influencing the environments they interact with. And so again, going back to the comment about the OECD's attempt, I think, to future-proof the definition, the EU also did this in a mechanism whereby they have specific AI approaches, if we can call them that, in an annex, where they specifically list out things like machine learning, knowledge-based approaches, and statistical approaches. All right, so what can we learn from each of these prominent definitions that exist out there for policymakers? Well, I think, again, it's important to recognize that they didn't just try to define AI, because intelligence in and of itself, right? Just speaking of human-based intelligence, philosophers and very smart people have had a hard time, neurologists even, right, have a hard time grappling with what exactly is intelligence. and defining that. So artificial intelligence is just necessarily more a complicated thing to define. So I think that goes some way as to why these policymakers have defined it in terms of systems, because then we have some sense of, okay, maybe it's computer hardware and computer software that's doing something of an AI nature, but we're more concerned with the fact that it's a system. So I think that's an important commonality amongst all three of these. Also, really important, I think in the past, there have been sort of waves of prominent AI technologies, right? So back in the 80s, a very prominent technology would have been a knowledge-based expert system or symbol-based system. Today, I think a lot of the venture capital goes towards machine learning systems. And so there's definitely subclasses underneath machine learning, but in the sort of the broadest sense, machine learning captures a lot of the breakthroughs that we've seen, and I'll touch on some of those. So I think it's really telling that policymakers were wise enough to explicitly pull machine learning into each of their definitions. Additionally, each of those definitions that I just shared with you suggest some level of human involvement. So either there's a human that's defining some objective for the algorithm to run. Even if it says, there's a minimal interaction, it still implies that there is some interaction or some oversight by a human being, or even, the fact that you have to take some human data point about what we're doing to actually make sense of that AI system. So there's still a tie-in in each of those definitions to how humans are involved with these AI systems. And going back to the point I made about how difficult it is just to define intelligence, my read of these definitions is that policymakers are they'll use the word human in some sense as a proxy for intelligence. So we don't have to define intelligence, but if it's something on par or akin to what a human being would do, that sort of gives some inference as to what level of intelligence we're speaking of when we define these systems. And equally, each references decisions as an output of such systems. So I think there's a lot of thought that's gone into this, but most artificial intelligence systems today really, I think you could argue that they are, in fact, they're either a decision machine or they're a prediction machine. There's some system that's using linear algebra and a machine learning system that's reducing some set of inputs down into what it perceives, the algorithm perceives as the most likely outcome, or something that a human being would appreciate as a decision to make or a prediction to follow. So those are all, in all three of those, I think those commonalities exist across all three of those. But in the EU and the US definition, I think it's important that they explicitly refer to software, because as we'll see when I get into some specific patent law issues, a lot of the matter that we deal with in software and the complexity of how do we treat software under patent eligibility law, especially in the US, how does that bear when we get into the AI context, and are those issues the same? I would argue they are. There's a lot of overlap in just plain old fashioned software and those issues that we see in AI today. So again, AI is an umbrella term, right? There's just not a lot of specificity in just mentioning AI. As I mentioned before, in the past, there's been these waves of technology that have come into favor and been the sort of the mode du jour for the time. Evolutionary algorithms, maybe they didn't have their great period in the limelight, but things like expert systems were very prominent in a lot of the 1980s-ish AI systems. But today, on the right side of the umbrella there, we're really talking about machine learning in most instances when we're hearing about AI advances in the news or from whatever blogs or wherever we're getting our information. But and under machine learning, so that's sort of the broadest moniker. You have then, neural networks or artificial neural networks, as you may hear them referred to. And then you've got deep learning as a subset of neural networks. And so that deep is implying that it's not like deep thought or deep cognition, like, oh, he's lost in deep thought. No, it's more about the architecture, the size of the nodes that are interconnected there in that architecture of a neural network. It's so big that they call it goes deep, right? It's a deep learning architecture. So, those are types of AI, I would say. So those AI systems, they can then be applied to various numbers of use cases. And so I think it's important when policymakers think and talk about artificial intelligence, they have to distinguish, the technology from the actual use. And so things like driverless vehicles may be enabled by some underpinnings of an AI algorithm. Obviously, there's been a lot of breakthroughs in natural language processing and all the applications that come through just being able to speak with a computer, with a machine, right? Having it understand you and equally being able to respond coherently to you. We've seen a lot of advances in robotics that are based on AI, as well as a lot of commercially marketable technologies like recommendations or advertising systems or anything of that nature, right? So those things are all probably based on some AI type algorithm, but they're not necessarily, I would argue, AI per se. They're uses of AI, if you want to speak of it. And so on this slide, you can see some of these great advances that are most recently in the news, right? And in my very technical scale of AI-ness there at the bottom, right? So on the left, you know, you have things that maybe at one point in time, everyone was really blown out of the water and thought that these were really fascinating advances in AI, but they've become more and more integrated into our daily lives. They kind of lose that novelty appeal to things like biometric passwords, right? Using your fingerprint to log into your laptop or unlock your phone with your face. Email spam filtering, right? Everybody takes that for granted, perhaps, but it's largely driven by sophisticated AI algorithms. And all the digital voice assistants that we use, the communications that we have with our Alexas and Siris and whatever other devices that are out there, right? Versus, so those are they AI? Are they not AI? That's debatable maybe, but then you have things that are on the right side here that I think are squarely well understood to be cutting edge, most sophisticated high-tech applications of AI we have today, right? So Meta has their open pre-trained transformer that was trained on 175 billion parameters for natural language processing. You probably saw recently there was a Google engineer that thought that the chatbot NLP that they had designed, Lambda, was somehow sentient. And this man was convinced that the machine had come to life and had a soul and whatnot. You had DeepMind with their AlphaFold technology, where we see such advances in sort of pharmaceutical research and protein structuring and modeling that is definitely going to advance medicines at a great clip here going forward. And then OpenAI as well, not only their GPT-3, which is another large language NLP type system, but you've got the DALL-E 2 architectures, which are really neat. You can play around with them online, where you can generate images based on a text, so the computer will come up with these new images. So definitely teasing some copyright issues there perhaps. But there in the middle, I somewhat in jest, I have this serialized deep learning. So back in 2006, when that term was first coined, till some point in the future, there's a lot of researchers in the AI field that today are starting to make claims that deep learning is maybe the most advanced subset of machine learning that we have out there that underlies a lot of those things on the right here. That's probably not going to be the path in and of itself to sort of a generalized artificial intelligence that becomes akin to a human level intelligence. So we may be seeing new models, I would expect, in the very near future. So stay tuned for that. But I think there's starting to be a realization that just alone deep learning is not going to get us to this artificial general intelligence state. So now when we get specifically into patent law issues, I think it's really important to distinguish the impacts of 3 different fields of AI that we can term here and how they're going to impact innovation or invention. And so the first is sort of what I've been talking about, right? It's these very fundamental building blocks, these algorithm structures that advance this computer science branch of artificial intelligence. And so the example I have here is of AlexNet. This was back in 2011, 2012. There was a ImageNet contest where you were scored basically how well your algorithm could differentiate images, right? So is it a cat or is it not a cat, right? And so AlexNet blew the competition out of the water at the time by scoring well above the past historical metrics. And so that architecture that they used and the hardware implementation, this is where we get into the graphics processing units, the GPUs that have come to prominence in machine learning and deep learning. This was sort of the beginning of that back in 2011, 2012. And so you can see that structure, the hardware implementation, that's going to be something that I would term a core AI, something that is really just the fundamental building block of the artificial intelligence system. Then you can talk about applied AI, and that would be those use cases that I mentioned before. If you have that AlexNet and you apply it specifically to recognizing, let's say, a human being's face for unlocking their phone, right? That could be a specific application of the AlexNet to some facial recognition application for phone security. And so if you're applying some generic structure, let's say at a certain point, right, you can use AlexNet and you can repurpose it, you can train it on different things. you will then become, some other discrete use for that particular building block. That's going to be an applied AI. And then third, you have what is maybe the most fascinating and the most interesting ramifications for patent law, and that is what we can term inventive AI. And that's going to be inventions that are output of an AI architecture. And so there's claims that there have been cross bristle brush toothbrushes designs. There's been antennas that have been designed. And so these things that are actually the output that don't really have anything to do, like a toothbrush, it's not high tech by any means, that I would argue at least. That's not really going to be anything to do with AI, but the important fact that it was generated through some sophisticated AI system or AI algorithm. And so we have to differentiate the level with which that tool has actually played into that innovative process. So once we can distinguish with these three, with that background in mind, I'll turn to some discrete patent law issues that, just tease them here. I think I've probably got a couple minutes left, and then we can maybe pick them up through questions or later. But the first of which goes back to what I said before about how artificial intelligence is really, at its core, it's very much a subset of software generally, right? So we have a host of issues in the US. So this, of course, is the statute for the United States Code. Section 101 is our patent subject matter eligibility statute. On its face, very straightforward, but in judicial application, it's become the subject of a lot of ambiguity. And so we have one particular judicial exception that the Supreme Court has told us, and that goes to abstract ideas. And so abstract ideas has, sort of created a lot of issues in the certainty of issuance of patents that involve computers or software or hardware interactions. And so I think today we're still going to be grappling with that because AI is still a subset of that. And despite many attempts to get the Supreme Court to come back or have Congress enact some clarity, we're working on it, but we're still not there yet. So I think this is definitely an area to stay tuned to make sure that AI innovation, those core AI innovations, can really remain patent protected and incentivized. So I'm gonna skip over novelty if you're familiar with patent law and go from 101 not to 102 but to 103. I think a lot of the obviousness issues are maybe more interesting because 102 is novelty. That's just a one-to-one correlation. If something exists. But when we get into 103, now we're in this realm of inventive step, right? To what degree must your invention rise so that it actually is not just some routine toiling or something that is not really inventive, but it's really something that's so useful and groundbreaking now that it's non-obvious, that there was some inventive process that went on that give it a rise to something that no one of ordinary skill in the art would have understood. And so you've got some breakthrough things. So this is a subjective standard for sure. But I think the implications for AI here are going to be that when we have levels of skill in a particular field, if they're reliant on artificial intelligence systems, then that's definitely going to necessarily increase the bar for patentability, I would think, under 103. Take, for example, the AlphaFold or any sort of drug discovery tool that's AI-based today. I think once you see those in labs around the world, that's going to necessarily raise the bar for what is non-obvious, what is inventive for pharmaceutical compounds or any other field of technology, right? Because, of course, there's going to be a host of applications for AI systems in the future. And so this will affect this legal construct that is the person having ordinary skill in the art. So if we all are sort of enabled and enhanced in a sense by some artificial intelligence system, then at some point patent examiners are likely going to have to account for that enhancement in the field of the level of skill in the art. So here I've got the inventorship statutes 115 and 116. I think this is a really interesting field because, like, excuse me, going back to the concept of inventive AI, if you have a machine, an AI system that can output things, what is the effect of that? How do we deal with that and treat that on inventorship grounds? And so we've got our federal circuit ruling out there that's currently on appeal to say that, under current statutes, you must have a human named inventor. So, but if there is some significant contribution from a machine, to what effect is that? Will that stifle the ability of a human being to get a patent if they used an AI tool? And if we did ascribe inventorship to a machine or give it some joint inventorship status, I think there's some other issues that we're going to have to grapple with. For example, we're going to have to rewrite our statutes on oath, or like an inventor's oath or declaration. So this is basically a statement that a human being signs today to say, yes, I am the true inventor of this thing. And if you have joint inventors, they would each submit their own oaths or declarations. And so obviously, unless it's a robot with a handwriting algorithm, it's not going to be able to do this or digitally sign something somehow. So we're going to have to definitely rethink that. Equally, in sort of litigation, there's going to be a question of, how, if you wanted to ask the inventing machine a question, how would we facilitate that? Would they have to necessarily be some requirement to build in some NLP functionality so the machine could give itself its algorithmic, internal functioning somehow? So these are challenging issues to think through, but definitely that's what we're doing today. And also, if there is going to be that level of sharing between a human and a machine, is that what we want to do? Is that the direction we go in to afford some joint inventor status? So today, under US law at least, just designing a problem and then having a machine execute on it, case law would say that that's not enough for the human being to be the inventor as the designer of the problem. But you remember from those definitions, it was acknowledged that AI systems often, they receive some human oversight, they receive some defined objectives from a human being. So that this is going to play in there somehow. And then ultimately, if you did ascribe some rights in a machine, the question of how would you vest those rights in the machine itself, and would they just sort of be go back to some guardian ad litem or some other legal construct to make sure that the rights are appropriately held in some fashion? So these are fascinating issues that we're actively dealing with today. So even beyond the patent law implications, I think there are innovation impacts that are really crucial and requires some serious deliberation and contemplation. And that is, if these AI tools, as we saw on that slide, with the number of AI breakthroughs in recent times, those are only held by a handful of companies, right? So if one of these AIs, let's say, the singularity ignites and these AI systems take off and they really become AGI, what is the effect of that? If one company owns that and we have this supreme intelligence, what impacts on society is that going to hold for us? Is that going to be good? Is that going to be bad? Will we need some tool to break that apart? Will there be competition issues there? And arguably, these issues would go far beyond patent law or competition law generally. Today, we've got some news out there that there are attempts at prior art generators. So these are AI systems that just generate inventions. And so I mean by that is that they're creating specifications of patents, basically, so that an examiner could use them. So if you got a tool that was really good at just generating specifications that a patent examiner could then rely on that to reject a human being's invention, is that, what is the effect of that, right? Is that going to stifle human invention, and do we want that to happen? Or even assume the ultimate state that I just mentioned, where you have an artificial general intelligence, right? Something akin to human intelligence, if not beyond that, and you can just tell it, hey, look, we've got climate change, we've got food shortages. Like, how do we deal with this machine? And the machine solves it, right? Do you even need a patent law at that point, right? If we get that sophisticated in our technology, after all, at least in the U.S., the underpinnings of the system, right, are to sort of incentivize inventors and authors. So, do you need a patent system to do that if you have such an advanced technology that it alone can really solve all of humanity's issues? And so, I'll leave you all here with this image of, the Alexa versus HAL from Kubrick's 2001, two very different flavors of artificial intelligence. We've got the very brittle NLP technology that's based on Alexa today versus, in the movie, HAL has the ability to solve problems, find problems, compete with humans, and try to, in fact, kill a human being. But I think ultimately, the human wins in the end. If you haven't seen it, definitely, spoiler alert, go see it. The human wins, arguably. So I'll leave that there. And I think this is probably a good segue into Dr. Abbott's presentation. Thank you for your attention.